Welcome back to Senate Education Friday, March 18th, 3:30. My apologies to our witnesses that have been waiting. We have had a longer discussion than expected on S248. We're now shifting to S716, an act relating to making miscellaneous changes to education. There are a number, actually, it's not a terribly long bill, as you know. The one thing I should say ahead of time, what we're hearing the most from right now, we're hearing from constituents, a lot of constituents, who are concerned with the delay in the special education rule. I would say, I mean, every day we're getting more and more and more emails. So that's something that I'm particularly interested in hearing your thoughts on. But of course, we want to hear your thoughts on the bill overall. And why don't we jump right in? Ms. Simmons.
Hi, committee. Emily Simmons, General Counsel, Agency of Education. Happy to take it from the top of the bill. There really are just two provisions in this bill.
Yeah.
So the first I would call a smoothing provision. This was recommended by the Agency of Education to recognize that 2018, when the math for the census block grant was first envisioned, is a little longer ago than we expected it to be upon first implementation. And so the shift of the years included to closer in time is intended to capture a better sense of the reality in supervisory unions and their more recent spending. So you'll see that 2018.
You are looking at the amended version, correct? There was an amendment that Ways and Means passed, and I understand it passed the floor that way.
Correct. So the supervisory union will get the benefit of whichever calculation is larger. Recognizing that, I think I did not listen to the testimony in House Ways and Means, but I understand it as providing for the circumstance where perhaps spending went the other direction than the general trend in a supervisory union. So the agency supports that change as voted out on the floor.
Okay.
Then the second change is around the delay of two very particular rules in the state board's newly enacted Rule Series 2360, which are the substantive special education rules. The Agency of Education feels that we're ready and the rule should go forward. We support going forward with the rules in total, not this pause in implementation. With that said, we understand where the field is coming from. Those that you will hear advocating for this delay have some valid concerns, but as far as those are around the unreadiness of the agency, we actually feel that we're ready. We have materials that have gone out and are going out to the field to provide professional development around these changes. And we think the rules should go forward in total on their regular effective date, which would be this coming July 1.
Okay. Yes, Senator.
To be clear, are you opposed to delaying it, or are you for doing the current date, or are you somewhat ambivalent and you just want to make clear there's no objection?
We're for going ahead. We're so against the delay.
Okay, thank you.
So no delay.
Okay. Against what the House passed.
Okay,
She's against the House.
Yeah.
Yes, Senator.
Just for clarification, Emily, do you guys specify that you are against the delay in the House?
Against Section 2 in the House. Yeah, that's right.
Thank you.
Okay. Anything else from you, Ms. Simmons? Okay. We're considering adding things, of course, to the bill, and we'll have you back in as we work on those things. But as the bill stands right now, it's great to have your thoughts. Mr. Nichols.
Good afternoon, committee members. For the record, Jay Nichols, Executive Director of the Vermont Principals Association. I'll keep my testimony brief as well. I was in the House when the discussion was brought up around the 2018 through 2020 or 2019 through 2021, whichever one is more beneficial to the school system. And I think that's a welcome change to the bill. So we appreciate that they did that in the House and that you would support that. One of the things that we've been concerned with from day one, as we move from a census, move to a census block model, making sure that school districts have the resources they need and that we give them as much support as we can. And that support also needs to be related to professional development, fiscal, political, policy, all those variables that are part of this change to Act 173. And so with that said, in the House, those of us who represent the individuals who actually have to do the work to implement 173 testified that we feel the rule changes that would change rules in Vermont on what we term adverse effect and specific learning disability should be delayed until July 1, 2023. As the committee is well aware, school staff are overwhelmed. To expect them to make rule changes in many cases with no professional learning is not responsible. This is especially the case when the people that have the most work to do in this area, classroom teachers and special educators, will be off in a few months for the summer. And they're going to be expected to be ready to implement this at the beginning of the next school year. I too think the AOE is ready. It's not a question of the AOE being ready in terms of these two rules. It's a question of whether school employees will be ready. And there are some systems that will be 100% ready, but I fear that there are some that won't be. So I want to be clear, the VPA supports the Rule 2360 changes. We just asked to go in effect a year later than the rest of 173, which is already a monumental shift for our schools. And we're trying to get ready for this shift in the midst of a pandemic. We don't think there's a need to add extra complexity at this point for our classroom teachers and our special educators. And lastly, on that issue, I just want to say, I'm no expert in this area. However, we're fortunate in Vermont to have at least 3 experts that testified in the House on this very issue, who will be people leading this change. And I would suggest that you ask them to testify in front of your committee. Mary Lundeen, Jessica Spencer, and Megan Roy, all of whom are veteran special education directors, student services directors, have a very good understanding of the law, all of whom support the rule change, but all of whom feel that many districts won't be ready to be effective in implementing the rule changes in a few short months. Subject to any questions, that's all I have for you today.
Mr. Nichols, would you mind emailing those names to us?
It's right in my testimony, which I'll send to I'll
Perfect.
send right along in just a second here.
Perfect. And then my only question is, how long have we already, and I respect your comments about the pandemic, absolutely, and that teachers and other personnel have been incredibly busy handling all those things. How long have we already been working to implement these rules?
I'm not really sure I even know the answer to that question. When we when we talked about 173 at the beginning, we weren't really talking about specific rule changes. We were talking about how do we move to a model that's a census-based model and allows more flexibility. And we talked about having a lot of professional development. A lot of that did not materialize. I think there's some professional development related to these rules that the AOE is trying to stand up that are like modules that people could attend and trainings. What happens is that the districts that are the least resourced are the less likely to be able to avail themselves of those resources. And I just think people are so overwhelmed with the pandemic. And if I'm thinking I've got to implement this in 3 or 4 months, I would much rather be telling people you got to implement this in 18 months. But again, talk to those experts and they could give you more information than I can.
Appreciate that. Any questions, Senator Persler?
Well, just on your question, Chair, and Emily could correct me, but I think this rule was adopted by LCAR in like October or in the fall.
This past October.
Yeah, so
Okay.
even though it's 3 months from now, it's not like we springing on it 3 months from the implementation date. But Ms. Simmons, can you clarify when the rules were proposed in the whole process and timeline that they've gone through?
The rules were approved by LCAR and they didn't take effect, but they became final last April.
That's almost a year ago.
Okay.
I read them.
Huh?
I read them.
You read them wrong.
Okay, you're an alpha.
I am,
She's just a go-getter.
but I don't remember them.
So so they were, LCAR voted on April, but then there's 6-9 months process before it gets to LCAR That's where they're proposed. Do you know when the agency proposed them to, like, posted them to the Secretary of State?
I do. And then the important note on these two rule changes, so the rule change about adverse effect and the rule change about identification of specific learning disability, came up in the comments following the public comment period. The public comment period, I don't recall the exact month, Chair Olson might, it was in the fall, it was toward the end of the year in 2020. And then in December and January, the state board had a committee working on digesting public comment. And the text of these two rule changes came out of that work. So the first time the text of these two rules would have been publicly available would have been around January 2021.
Thank you.
Thank you. Any other questions for Mr. Nichols? Mr. Nichols, while we have you, if you don't mind, and this will also ask Ms. Sobolewski when she comes on, S-162 was on the floor today. You'll remember S-162 that you helped lead the compromise. I can see you're chuckling. You'll never forget it. So we were looking to maybe add just a slight change, and I'm going to ask Senator Perchlik to mention that change, and wondering if you might just weigh in on this. We don't think it's particularly controversial, but we'd love to get to some resolution on it before we get to the floor on Tuesday. Senator Perchlik.
This, if you happen to be listening to the floor on the 162, Senator Pearson had a question about the second section about protecting teachers or any school employees from discipline when they testify in front of the legislature or Board of Education. Senator Pearson asked if that protection also extended to testifying in front of school boards. And so afterwards he asked, like, can we just add "and school boards" to that section? So that's basically the question. Do you see a problem with adding "and school boards" to the places any employee of a school could testify without fear of being disciplined just for testifying, with the same caveats?
Mr. Nichols.
I'm sorry, I was trying to unmute myself here.
No
Apologize. So, no, I hadn't picked up on that. I had listened for a while and then I get distracted with phone calls and stuff.
Sure.
I was thinking you're going to get to 219 today. I was waiting to hear the outcome on that. So
Yeah.
what I would say is that as a superintendent, it was not uncommon for staff to come to a board meeting and share their thoughts on something at the board level, and there would be no discipline for that. However, there's a chain of command policy that every school board has. So I'd be careful about adding that. These are the employers of the person. So I'm not sure. I think I'd want to talk to a few legal eagles, and maybe Sue has more information on this, but what would concern me would be if a principal had to discipline a teacher or another staff member, and that person jumped over the superintendent and came to the board, for example, that's a violation of chain of command. It needs to go through me first as a superintendent. So
Right.
I just would be, if they're talking about a matter of general public interest and it's public comment time and they're using their ability to talk about that like anybody else, then I think that would be fine. But I just makes me a little bit nervous when it's an employee-employer relationship and there are rules governing how those relationships work in the day-to-day operations of the school.
Okay, thank you. That's helpful.
Okay.
And we'll ask the same of Ms. Sobolewski, but now we'll just move back. Mr. Olson, great. Thanks for being with us. We apologize for our tardiness. So what are your thoughts on the miscellaneous education bill?
No worries. Thank you. For the record, Oliver Olson, I'm the chair of the State Board of Education. The State Board of Education did have some discussion on potential delay of Act 173 in general back at its January meeting. At that time, much of the discussion was focused around the possibility of delaying some of the financial aspects, particularly around the census block grant. So that was the focus of our discussion, but we did talk about 173 in general, which is inclusive of these specific rule changes because they obviously came out as a result of Act 173. The board's position at that time was that there should be no delay to any provision coming out of 173, including implementation dates related to the census block grant and the associated special education rule changes, which would include these specific changes here. That said, there was some recognition that different districts were situated in different places in terms of ability to implement due to the effects of the pandemic, et cetera. And our position was that it would be wise for the General Assembly to consider some ways to ease the transition, particularly at a moment when we have the financial resources to do so. So certainly the first provision of 716 is consistent with our position and our recommendation. And I would suggest that with respect to the implementation dates around the adverse effect rule and its complementary rule, I would say that our position is in general should not be delayed, but to the extent that there are hardships, perhaps looking at a creative approach, as was mentioned earlier by Mr. Nichols, some districts may be prepared and able to execute against these new rules against the current timeline. Some may need additional time and training effort to do so. So perhaps there's a middle ground to be had. I can't say exactly what that might look like.
Well, you're making me think, what if it were almost by request? You know, if you have a district that's ready to go, you know, and so why not start best thing for kids? And then if you don't, perhaps it's, you know, you ask for a delay by, you know, for the Agency of Education, something like that.
Exactly. So the, you know, one, you know, caution, you know, I'm not the, certainly not the expert and would defer to the experts on either side of this particular question. But my understanding is that, you know, the new rules do introduce some subjectivity. So it's not as simple as, you know, making some online training available. There is a need for calibration to ensure consistency of the assessment process. So that's just something, you know, I think we should all be cognizant of as we're thinking about, you know, who's ready and who's not ready and how we actually determine that readiness.
Any questions? Good. Okay. Thank you, Mr. Olson.
Thank you.
Ms. Zeglowski, how are you?
I'm doing well. How are you?
Good, good, thank you. So as you may have heard, in addition, after you comment on H716, we would love for you to comment a little bit on the rule or the slight amendment / edit that we're thinking about for H716 or HS162.
I would be happy to.
Great.
Good afternoon, Sue Zeglowski, Executive Director of the Vermont School Boards Association. And on H716, my testimony will be very brief. I did testify for VSBA in the House Ways and Means on Section 1, the smoothing provision, and we testified in favor of that provision. I did not testify in the House on Section 2, but would ask you to give due consideration to the concerns that Mr. Nichols raised about sort of the people on the ground who are going to be implementing, and would also encourage you to hear from the 3 witnesses that Mr. Nichols mentioned. And that basically concludes my testimony on H716.
So you said you didn't testify in the House. So are you, by extension, you're saying you're also basically not taking a position, or the School Board Association is not taking a position on the delay now, other than to say you would like us to listen to what Jay said?
Correct.
Okay, thank you.
Thank you.
And I heard the question from Senator Perchlik on S-162. Would you like me to respond to that now?
Yeah, if you would please, that would be great.
Sure. So I would like the opportunity to respond in more detail on Monday because I haven't had a lot of time to consider the question. I just heard it this afternoon. But one key difference that I have identified is that, in the bill, it addresses testimony before the legislature or the state board, and they are not the employer. Whereas you're thinking of adding a provision to include the school board, who is actually the employer. So I think there may be some intersections with employment law that might need to be considered. And I'd like to get back to you about that.
We would really appreciate that. You both raised a really important point, and if you would, over the weekend, I'm sure you're busy with other things, but if you do have an opportunity, sometime by Monday, perhaps reach out to both Senator Perchlik and me. Feel free to copy anybody else on the committee as well, with what you consider to be sort of your final comment on it. Does that make sense?
I will do that. Thank you.
Okay,
Yes, thank
great.
you.
Anything else? Yes, Senator Chin.
I'll just say on the 716 delay or not delay, I'm generally very sympathetic to the schools, the principals, the teachers. They need a break. They need a light summer. But what I'm not hearing so far is what the workload implications are of this. So I do hope we take testimony from those individuals. Absent hearing that, I'm more inclined to not support the delay. But I don't know. I'd love to hear.
No, I think you're absolutely right. It'd be interesting to hear what that actual workload, what sorts of things have to happen, and how many districts we're talking about. If it's everybody, or if we would maybe move toward a request for delay.
I just have one last question on that. Either Jay or and Oliver has stand up, but either Jay. Jay or Sue can answer this question, and that is it? I know we do years delays often because of the school year, but is there any value in a partial year or something, or just throwing it out there? That doesn't work. Like you have to do it at the beginning of the school year.
Yeah, because you'd have your special educators and your folks that were actually testing kids to determine eligibility in the middle of a school year. So do we delay this one kid's test? I like how you're thinking, but I don't think that would work very well.
Okay, just
Yeah.
Mr. Olson?
Yeah, one suggestion, another person the committee may want to hear from is Superintendent Randy Lowe. And she happens to be my local superintendent. I've had some conversation with her. She has a unique perspective because she actually was a special ed administrator in another state that went through this transition. So she had a lot of lessons learned and observations that are very relevant to this transition that you might want to hear about.
Okay, we'll put her on the list. Thank you. Okay, anything else? I think we'll leave it there. Thanks, everybody.
Thank you.
Yeah. Thanks, everybody.